Today I'm going to take a look at McKenzie friends. You may not have heard of a McKenzie friend, but it is someone who is a non-legal person who provides assistance to a lay litigant in court. In the High Court in Ireland, however, in the last number of years, the High Court has felt obliged to bring directions for McKenzie friends and how they were to be conducted and how they were to carry on. Just to be clear, a McKenzie friend can provide moral support, can take notes and quietly help with advice, and there is other practice directions, but a McKenzie friend is not permitted to be paid for their services or manage the case outside the court. And apparently over the last number of years a number of individuals have set themselves up as advisors and charge for their advice and assistance, help with drafting affidavits and bringing motions before the court. And this is not something that the courts have approved of. In fact, it's a criminal offence pursuant to the Solicitors Act 1954 for a person without legal training to prepare a legal document relating to any legal proceedings for a fee or reward. And the small industry of fake legal advisors which sprung up to service the growth in the number of lay litigants bringing cases before the courts, a lot of these cases to do with debt and repossession cases, but the McKenzie friends could be broadly categorised in two categories. One, those charging money, and two, those with an agenda against the courts or the banks or some other agenda which they want to canvass at the expense of the lay litigants essentially in court. Justice Mary Irvine from the Court of Appeal raised her concerns about people taking advice from people who are not qualified and who have no understanding of the court rules and so on. She says day in, day out, this court sees lay litigants pursue appeals and applications which have no prospect of success. The courts have no option but to award costs against these lay litigants, pushing them further into debt. Justice Michael Toomey then went on in the High Court to describe a situation where there was a number of attempts to prevent the repossession of a farm, described it as an abusive process upon an abusive process, and in fact made an Isaac Wonder order against her, the lady in question, from bringing any further proceedings without the permission of the President of the High Court. The judge also went on to disqualify her McKenzie friend from acting as a McKenzie friend in future. And the judge in that particular situation noted that the McKenzie friend that he had disqualified apparently has a busy practice. And bottom line is, anyone who provides you with support when you're in difficulty with a legal matter is to be welcomed. However, a distinction needs to be drawn between support and legal advice. If you cannot afford a solicitor, consider looking for advice from the Free Legal Advice Centre, from Citizens Information, or applying for legal aid. Or indeed, the Insolvency Service of Ireland may be of use to you, or the Money Advice Budgeting Service, MABS. Now, as I said, there's a number of practice directions from the courts to do with McKenzie friends, and just to be clear about them, a McKenzie friend may provide moral support for litigants, may take notes, may help with case papers subject to certain conditions, and may quietly give advice on any aspect of the conduct of the case. McKenzie friends may not address the court, make oral submissions or examine witnesses or otherwise conduct litigation, may not receive any payment for their services, may not act as the litigant's agent in relation to the proceedings, and may not manage litigants' cases outside court, for example by signing court documents. So litigants may receive reasonable assistance from McKenzie friends. The court retains the power to refuse to permit such assistance. Only one McKenzie friend may assist the litigant in court, and the attention of litigants and the proposed McKenzie friends is drawn to the provisions of Section 58 of the Solicitors Act 1954 as amended, which makes it a criminal offence for an unqualified person, as defined in the Act, to draw or prepare a document relating inter alia to any legal proceeding, either directly or indirectly, for or in expectation of any fee, gain or reward. And that practice direction came into effect in October 2017. There was a practice direction after that then, and it came into effect in July 17. Basically, the court described or said McKenzie friends may provide moral support, take notes, help with case papers, quietly give advice. They may not address the court, they may not receive any payment, they may not act as litigant's agent, and only one McKenzie friend may assist a litigant in court. And there was a further practice direction from the courts in April 2018, and the President of the High Court, or the Acting President of the Court of Appeal and the President of the High Court, Mr. Justice Peter Kelly, made the direction that former solicitors who have been struck off the role of solicitors because of professional misconduct, and former barristers who have been disbarred for professional misconduct, may not act as McKenzie friends in either the Court of Appeal or the High Court. That's the situation in relation to McKenzie friends. They are help and assistance. They're there to provide support for lay litigants. However, the courts did become concerned that they were actually driving up the costs of cases. They were prolonging cases in circumstances where there was absolutely no prospect of success. And the bottom line is, if a litigant, a lay litigant, a party in proceedings is involved in legal proceedings, clearly, unless they're going to win, there's going to be a costs difficulty, cost issue. Costs do follow the event. That's the general rule. That's the legal principle, and there's statutory provision for that. So obviously you can go and prolong and bring motions, prolong your proceedings as long as you like, but the fundamental issue is that costs are being increased, and ultimately they're going to come to rest at the door of the lay litigants. So they're basically digging a bigger hole. McKenzie friends do have a role to play, there's no doubt about that, for lay litigants, but they need to be clear, and the lay litigant needs to be clear, I suppose, about the exact extent of the assistance that they can give, and obviously payment is not permitted. Hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button. Thanks for watching.